Very good morning, good afternoon, and good evening to all of you joining us from around the world. On behalf of the Singapore International Arbitration Centre, a very warm welcome to the SIAC Moot webinars, Navigating the SIAC Rules. We are delighted to have attendees from over 70 jurisdictions joining us today. My name is Ma Suen, SIAC's Senior Strategy and Development Manager Legal, and I'm pleased to be your MC. Some housekeeping matters. Please ensure that you have your full name on your screen so that we can easily identify you for record-keeping purposes. If you have any questions during this session, you may send us your question using the Q&A function. As we have limited time, the speakers will try their best to address as many questions as possible. Without further ado, I would now like to invite our speakers for today's webinar. Our speakers today are Deputy Counsel of the SIAC Secretariat. They are Mr. Andres Larrea, Ms. Margarita Drobyshevskaya, Ms. Joanne Heng, Mr. Nusri Hussain, and last but not least, Mr. Shivam Patanjali. I will now hand over the time to Andres, the moderator. Andres, please.
Thank you very much, Joanne. Good afternoon, and welcome to the first webinar in our Moot series titled Navigating the SIAC Rules. We are pleased to be part of your Moot journey, and we thank you for joining us for this session. My name is Andres, and I'm delighted to be your moderator for today's session and to be joined by my colleagues from Secretariat, Joanne, Margarita, Nusri, and Shiva. On behalf of the SIAC, we want to thank all the students, coaches, and arbitration practitioners joining us from around the world. Today's session is designed to help you understand the core principles behind the SIAC rules and learn how the rules operate in practice. Now, before we dive into the rules, let me begin with a quick overview of the SIAC. We were established in 1991. SIAC is an independent, not-for-profit arbitral institution that administers international arbitration cases. Now, most of our cases, as I mentioned, the ones that we administer at the institutions are international in nature and involve parties from over 100 jurisdictions. Today, SIAC operates as a truly global institution with offices in Singapore, New York, Mumbai, Kyiv City, Shanghai, and so on. Now, in 2024, SIAC recorded one of its highest caseloads, 625 new administered cases, reflecting the continued trust that our users place in the institution. 2025 marked a special moment in SIAC's history with the launch of the 7th edition of the SIAC rules. I have a copy here with me. These rules are the outcome of an extensive public consultation process. Throughout that process, we listened carefully to what our users wanted. Efficient arbitration proceedings, which allow parties to save time and cost and without sacrificing quality and due process. These needs certainly shape the guiding principles set out in Rule 3.5 of the SIAC rules, that every case shall be conducted with fairness, efficiency, and enforceability of the award in mind. Now, with this context, with this introduction, let me begin by exploring the spirit behind the SIAC rules. And I would like to start by asking each one of our panelists to share, in one word, how would you describe the guiding principles behind the SIAC rules? Then we will build our discussion around those keywords shared by my colleagues. So let me start with Joanne. Joanne, what would you say is one word that describes the SIAC, the spirit of the SIAC rules?
I think for me, the word really has to be efficiency.
Efficiency. Thanks, Joanne. How about you, Margarita?
For me, it's innovation.
Innovation. Great words. Shivam?
I think for me, the word would be transparency.
Transparency. So we have efficiency, innovation, transparency. Nusri, how about you?
For me, Andres, I think I would say flexibility.
Flexibility. All great words. Thanks to our speakers for their chosen words. And based on that, let me begin with the word chosen by Joanne, efficiency, because certainly parties all over the world put a big emphasis on having arbitrations being conducted in an efficient manner. And Joanne, you mentioned that efficiency is one of the guiding principles behind the SIAC rules. And we note that there are rules which promote efficiency. For instance, those that try to reduce the time for making an award. And one example that comes to my mind is the expedited procedure. This EP procedure was first introduced by SIAC in 2010, and since then we have received over 1,000 applications. Almost 598 applications were accepted, which means that it's a very popular feature used by the users. And my question to you is, how does this expedited procedure reflect SIAC's guiding principle of efficiency?
Right, and thanks, Andres, for pointing out the expedited procedure. So the expedited procedure is, I think, one of the fast-track procedures that SIAC has. And the idea is that, from the time of constitution the tribunal to the time of issuance of the final award, that should actually be 6 months. And, for our standard procedures, that generally takes, I think, a median of around 13 months. And I think the thinking behind that is that there are some cases where fast-track procedures are suitable, and it may be more of an in and out situation. And I think to accommodate that the award will be made within 6 months from constitution of the tribunal, what we have is that as a default, there will be no evidentiary hearing, and the arbitration will be decided on the basis of written submissions. And, in assessing the needs of the case and how the arbitration proceedings are going, the tribunal may also decide that there will not be document production. So there are kind of different procedures in place to kind of guide the arbitration along to help it move as quickly as possible and to get the award out in 6 months. And normally how the expedited procedure applies is that there's two situations. The first is under Rule 14.1 of the SIAC Rules 2025. And that's really a situation where parties have agreed beforehand. For example, the arbitration agreement might literally say, any dispute arising out of this will be, conducted by expedited procedure under SIAC rules. And so that's where you have a prior arbitration agreement. And the more common situation, which I think we really see, is situation in Rule 14.2 of the SIAC rules, where there's no express agreement per se, but a party will really make an application with the registrar of SIAC for expedited procedure to apply. And the monetary threshold, as it were, is generally a dispute that falls between 1 million Singapore dollars and 10 million Singapore dollars. And I think, we at the SIAC Secretariat are also involved in looking at these expedited procedure applications, and we will look at a case holistically to see, what are the issues in dispute, what are the legal issues that have been raised, who are the parties, and then overall we try to come to an assessment on whether or not expedited procedure is appropriate for the case.
Thanks, Joan. Definitely, the expedited procedure is one of the key features of SIAC, and it's definitely showcase the efficiency on the rules. And I have a question building on what Joan just mentioned, Shibam. Is there any other rule that comes to your mind when we are reflecting on this principle of efficiency under SIAC rules? Could you give us an example of another rule and how this works in practice?
Thank you for the question, Andres. There's a personal favorite provision of mine when it comes to SIAC's commitment to efficiency, the emergency arbitration procedure found in Rule 12 and Schedule 1. Now, this mechanism allows a party to seek the appointment of an emergency arbitrator to obtain urgent interim reliefs before the tribunal is even constituted. An EA application can be filed either before filing the notice of arbitration or at the same time as filing a notice of arbitration. Last but not the least, anytime before the tribunal is constituted. This procedure is designed for situations where waiting for the tribunal to be constituted would risk irreparable harm or immediate danger. Some common scenarios include the urgent need to protect assets, the preservation of evidence, parties perhaps seeking a temporary injunction order. Now, efficiency is at the heart of this process. What I mean by that is, once this application is received, the president of the SIAC Court of Arbitration, should she determine that this application should be accepted, appoint an emergency arbitrator within 24 hours from the date of receipt of the complete EA application. Once an emergency arbitrator is appointed, the emergency arbitrator has 14 days to issue his or her order or award. These 14 days include a hearing that may take place as well as the Secretariat's scrutiny of the draft order or award. Behind the scenes, the Secretariat works diligently to ensure these timelines are met. And I generally enjoy dealing with these applications as they showcase SIAC's dedication to efficient dispute resolution. Not only does emergency arbitration help secure interim relief within a tight time frame, but it also provides parties with an early snapshot of the case's strengths and weaknesses. In my experience, in fact, this often leads to settlement soon after the procedure concludes, further underscoring its practical value.
Thank you very much, Shivam and Joanne, for those insights. And it's clear that efficiency remains at the heart of what makes SIAC attractive to users. Now I'd like to move on to the next guiding principle. The word that you mentioned is innovation. And Margarita, you mentioned this word, and I think this word is very important because Shivam mentioned earlier how emergency arbitration provisions are one of the key features under the SIAC rules. We know we are familiar with emergency arbitration provisions, but under 2025 rules, the SIAC rules introduce this protective preliminary order. And what does this mean? How does this protective preliminary order under the new SIAC rules reflect the innovative principle behind the rules? Margarita.
Thank you, Andres. I agree that SIAC rules are drafted in a way that ensures that they reflect the past, present, and future of SIAC arbitration. And SIAC Rules 2025 continues this tradition and showcase the SIAC commitment to innovation. And of course, one of the features is the introduction of the preliminary protective order, or we also call it PPO, which is unique to SIAC. Protective preliminary orders allow party to seek urgent relief on an ex parte basis, meaning without notice to the other parties, with the aim of preserving the status quo until the application for interim relief can be fully heard by the emergency arbitrator during the emergency arbitration proceedings. The emergency arbitrator shall decide the preliminary protective order application within just 24 hours of the appointment. And let's take a simple example to illustrate how this application can work. Imagine a party discovers that the counterparty is about to transfer assets overseas to frustrate the future award. In such a case, the party can apply for a preliminary protective order to freeze the situation immediately, even before notifying the other side. If the preliminary protective order is granted by the emergency arbitrator within the 24 hours after its appointment, it holds things in place until the emergency arbitrator can hear both parties and decide on the appropriate interim relief. But because ex parte relief can raise some questions of fairness, the preliminary protective order mechanism has been drafted and designed with some safeguards to protect both parties. The applicant must immediately notify the counterparty once a preliminary protective order is made by the emergency arbitrator, and the order automatically expire after 3 days if the notice is not given. The emergency arbitrator is also required to promptly deal with any sort of objections from a counterparty to the preliminary protective order, and the preliminary protective order shall in any event expire within 14 days of it's been made by the emergency arbitrator. And of course, the emergency arbitrator has power to adopt, modify, or vacate the preliminary protective order as appropriate after hearing the submissions of the parties. In that sense, the preliminary protective order, I think, perfectly captures SIAC approach to innovation. It's thoughtful, it's user-focused, and responsive to real-world challenges which may arise in the international transactions. For us, I think innovation is about not only the change for the sake of the change, it's about the developing procedures that make arbitration more efficient and accessible. And I guess the preliminary protective order is a clear example of that in action.
Thanks, Margarita. And I really stay with your last words. It's true. It's really the PPO. It's one of the innovation tools in action. And it's great to see how it has been introduced as an extra layer to the emergency arbitration proceedings. And it's very helpful for the examples that you were describing before. Now, Shivam, the PPO is not the only new kid on the block. Can you share with us if there are any other innovation mechanisms introduced under the SIAC Rules 2025 that we should be aware of?
Thank you for the question, Andres. Now, it was often said that sometimes the costs associated with traditional arbitration often acted as a barrier for parties pursuing low value claims. Now, the streamlined procedure found in Rule 13 of the SIAC rules, read with Schedule 2, recognizes that a one-size-fits-all approach is not appropriate and is in fact designed to help make arbitration a viable option for smaller claims. This procedure applies automatically when the sum in dispute does not exceed SGD 1 million prior to the constitution of the tribunal. Now, unless parties can in fact opt out of the streamlined procedure by making an application to the president. Alternatively, another way that the streamlined procedure can apply is if the parties agree to its application before the tribunal is constituted. Now, streamlined procedure arbitrations are conducted as follows, as a default, a sole arbitrator is to be appointed. Now, unless the tribunal determines otherwise, the default position is that the arbitration will be decided on the basis of written submissions and documentary evidence only. It's going to be decided without document production or filing of any fact or expert witness evidence. And in the event a hearing is conducted, the default is that the hearing will be conducted virtually. One of the important aspects of the streamlined procedure is that the arbitrator must issue an award within 3 months from the date of the constitution of the tribunal. And yes, the 3 months also includes a scrutiny process undertaken by the Secretariat. We're talking about how this procedure is designed to make arbitration, in fact, more viable, for smaller value claims from a cost perspective. And under the streamlined procedure, the tribunal and SIAC's fees are capped at 50% of the maximum limits calculated in accordance with SIAC's schedule of fees. For example, if the tribunal's fees under a normal procedure would be capped at, say, 100 Singapore dollars, and SIAC's fees capped at around 20 Singapore dollars, under the streamlined procedure, the tribunal's fees would then be capped at 50 Singapore dollars, and SIAC's fees would be capped at 10 Singapore dollars. This abbreviated process and strict timeframes are designed to result in meaningful cost reductions and quicker resolution. In fact, the 3-month timeframe for an award, subject to extension by the registrar, is half of that of the expedited procedure, which we spoke about earlier, making it one of the fastest institutional procedures available globally. The streamlined procedure is well suited for parties with low value or less complex disputes. For example, straightforward debt recovery claims or cases turning on, issues where facto expert witness is not required. And I think this procedure, is a great example of how SIAC continues to evolve to meet the needs of its users.
Thank you, Shivam. And it's very fascinating to me how we, even though now we're speaking about innovation, it just connects to the previous idea of efficiency with the streamlined procedure, which is an innovative, an innovation tool. It also contributes to having more efficient arbitrations. Now, in the same line of innovations, because when I read the 2025 rules, Nusri, I see that there are different mechanisms, new mechanisms in the rules. And another mechanism that I bump into is the coordinated proceedings. And my question to you, Nusri, is why is this an innovation? Why do we need this in the first place? How does it differ from consolidation to begin with? Could you share with us a little bit more about the coordinated proceedings under the SIAC rules?
Thank you, Andres. I think coordinated proceedings cannot be spoken without consolidation, because the very basis of a claim not being able to be consolidated does not bar you from having them heard together. Now, that is what the coordinated proceedings have tried to do. Now, first, let me tell you for our audience as to what consolidation is, so that they'll have a better understanding as to why parties wouldn't consolidate and proceed to coordinate. So consolidated proceedings is basically where the parties, there are 2 mechanisms under the SIAC rules. One is before the constitution of the tribunal, and Then you have post-constitution consolidation. That is where the tribunal has been constituted, and then subsequently you have applied for consolidation. Now, prior to the constitution of the consolidation, where the parties have agreed, or where the claims and the cross claims are under the same arbitration agreement, or the arbitration agreements are compatible and the disputes out of or in connection with the same legal relationship arise out of a principal and ancillary contract, or the transaction is of a series of transactions. So you want to bring all these arbitrations together as opposed to having parallel multiple arbitrations. Now, this is in the spirit of having cost-effective, efficient arbitration. Now, in scenarios where you cannot consolidate these arbitrations, for example, let's say the parties cannot agree, or let's say the claims don't arise under the same arbitration agreement, right? Or let's say, for an example, the classic case would be you have an arbitration that has commenced under the 2016 SIAC rules, and the tribunal has been constituted, and subsequently you have a case that is commenced under the 2025 rules. Now, these are two different set of rules, and therefore the arbitrations are not compatible. So you cannot consolidate, right? So the solution that you have is to coordinate these proceedings in terms of Rule 17, right? So what happens when you coordinate these proceedings, unlike the consolidation procedure where you can apply prior to the constitution of the tribunal, a coordinated proceeding is applied to the tribunal itself. Now, for that, you need the same tribunal being in place. Now, so basically, what happens once you consolidate the proceedings is that the arbitrations are conducted concurrently and sequentially, and the hearings are held together, right? And so sometimes in certain instances, the arbitration is certain arbitrations are suspended until there is a determination on any other arbitration. Now, the question arises as to how does this help, right? The question arises as to how does this help? Because if you have multiple cases, right, which the parties are okay to consolidate, but they are unable to consolidate, your next best option is coordinate, right? So you save a lot of time, you save a lot of money because it's going to be the same, but the main key thing is confidentiality as well. You have to maintain confidentiality. So as a result of that, you need different orders and different awards. Procedural orders are different. So there are multiple protection mechanisms within the rules as well to ensure that coordinated proceedings maintains that obligation of confidentiality among the other arbitrations as well. And I think that is where SIC has come forward. I mean, yes, this has informally been done in certain instances, but I think SIC has, in a way, brought in this provision to codify so that the parties have certain structure and predictability as to how they can proceed with coordinated proceedings.
Thanks very much, Nusri. And I think, once again, it's so interesting to see how all the ideas connect each other. It's an innovation, the coordinated proceeding, but at the same time is a way to promote efficiency, and it's all built in the DNA behind these rules. Now, we have discussed some procedural rules, but I think that if we're talking about innovation, it's quite imperative in the world that we live in that we touch on technology, because there is a huge intersection between arbitration and technology. As I am a huge tech fan, so one thing that I could not help but notice in the SIAC Rules 2025 is the mention to the SIAC Gateway platform, which was launched by the SIAC. And Joanne, the question is for you. Could you share a little bit more with us? What's the idea behind this platform, this gateway platform? What's the idea behind its design? How does it work? And how does it contribute to the principle of innovation that we have been discussing in this panel?
Right, thanks, Andres. I know everybody has been talking about innovations in the SIAC rules, but this form of innovation, I think, is a little different. So, just to highlight to everyone, I think if you look at Rule 6.1 of the SIAC rules, there's a little mention that claimants can now file notices of arbitration online through the use of SIAC Gateway. To understand, I think, how Gateway fills a very specific need in arbitration, it's maybe helpful to give you some context on how arbitrations are run generally. So I think from my experience so far, and I'm sure, everybody else in Secretariat might agree, I think arbitrations are conducted across, I would say, a variety of different platforms in the sense that, you have the regular correspondence that's shared by way of email. And then, if the files are too big or you need to submit like memorials or witness statements, law firm A may say, please use my law firm, sharing link, and law firm B will say, please use my law firm B sharing link. If there are hearing bundles, in advance of the hearing, those may be hosted on a separate platform. For example, sometimes parties choose to outsource the preparation and hosting of the bundles onto a external vendor. So that's an entirely different, website. And I think what we really wanted to do was create a place where the entire arbitration can be hosted, I think, in terms of correspondence, in terms of, documents. We really wanted to have something that could almost be like a one-stop shop, I think, in terms of arbitration. So to explain what Gateway is, it's really a cloud-based case management platform. It has e-filing features. You can make integrated online payment. You can also, there's secure document upload and document storage, which I think is really important, bearing in mind the confidential nature of arbitration. And it will also allow for real-time case management. And I think one of the additional appeals of the use of SIAC Gateway is that parties and tribunals can actually, opt in and decide to use SIAC Gateway at no additional cost. So I think from what we have observed so far, there's been quite a number of parties who have chosen to file their notices on Gateway. And I think we are slowly rolling out all the different features, but I think at this point, it's mainly used for e-filing, and then we're looking forward to seeing it develop into, I think, a fully fledged case management platform that will really be able to assist parties and arbitrators.
Thanks very much, Joanne. I think it's so interesting to see how the SIAC does not only design these rules, but they also have promoted a platform such as Gateway, which is so useful in this intersection between technology and arbitration in order to, once again, improve the efficiency in proceedings. Now, I would like to move on to the next keyword that was mentioned, which is transparency. And I think that transparency is such an important word because it really goes to the core of the trust of the users in the system. So I would like to start with Nusri. Nusri, transparency was mentioned at the beginning of the session, and the first thing that really comes to my mind when we are talking about transparency are conflict of interest, which is such a trending topic. Everyone is talking about this. And my question to you, Nusri, is how do the SIAC rules handle disclosures when you are reaching out to potential candidates, and how does this process really strengthen transparency for our users?
Thank you, Andres. I think the key thing is to understand the rules itself, the obligations on the arbitrators. If you go to Rule 20, you talk about the obligation on arbitrators to be independent and impartial at all times and conduct themselves in a professional and in a manner and in terms of the SIAC rules. And in terms of Rule 20.2, you have that the arbitrator is, prior to his appointment, is required to disclose any circumstance that may give rise to justifiable doubts as to his independence and impartiality. Now, on that basis itself, as soon as we receive the case papers, that is the notice of arbitration or the response to the notice of arbitration with all the annexures, based on all the documents that the Secretariat has, we go through all these documents, regardless of whether it's going to be 1,000, 2,000 pages. We go through the documents and we generate or create a list of all the parties, individuals and companies that are involved in this case. So we have this conflicts checklist. So we have generated a name list of all the parties involved based on the case papers that we have. We take that list and then we write to the prospective arbitrators. We write to the prospective arbitrators and tell them, look, there can be two scenarios. One is where the parties have nominated you as an arbitrator. So we are reaching out to you to confirm your availability, your independence and impartiality, and whether you have any disclosures to make. So we write to them with a statement of acceptance, that is in terms of the rules itself. And we send this list of names and of individuals and companies as well. So what they do is they go through that list, they see if they are conflicted, and then they make those disclosures in the statement of acceptance. So now this disclosure is made in writing. So once it's sent to us, we put these disclosures to the parties and ask their comments to see whether they have any objections to the disclosure. And as a result of that, we look at the IBA guidelines, so whether it's going to be on the orange list, the red list, or the green list, and those are things that we consider. Now, in scenarios, so this is a scenario where the parties have nominated. Let's say, for an example, the president has nominated an arbitrator, where in an instance where the parties can't agree on a arbitrator nomination, the president nominates someone. So we reach out to that candidate and tell them the president is considering you, let us know. So then we take the disclosures and the same process, we write to the party saying this is there. And all these disclosures are put to the president prior to her confirmation of the appointment. Now, the important thing that the Secretariat does is also, even before we reach out to the president for confirmation, we also clear conflicts with the president or the vice president or the person appointing that arbitrator. Now, this happens in any application, whether it's to the SIAC court or whether it's to the SIAC president, just to make sure that even us as an institution, the people making those decisions are not conflicted in matters. So we'll run that conflict check by the president as well, but we'll also write by the arbitrators. And as soon as there's any disclosure that is made, we put it to the parties. Now, let's say a party does not want to withdraw its nomination, or another party objects to the nomination, and we see that the arbitrator's disclosure, let's say, falls on the red list, on the IBA guidelines on conflict of interest, we'll write to the president and we'll tell her, look, we wrote to the parties, let's say the claimant does not want to withdraw its nomination. Are you minded to proceed with the appointment, right? What the president does is looks at the list, and in terms of the rules, Rule 9.3, the president can reject the nomination and ask the part claimant to nominate someone else. So those are powers that we have just to maintain the integrity of the award, because at the end of the day, the value of any arbitration is the final product, that is the award. And if you have an award that is unenforceable because of grounds of because of independence and impartiality, or that a certain arbitrator was conflicted, it just doesn't make sense spending all the time, money, and effort getting an award that is not enforceable. So that is that is at the back of our minds when we conduct any conflicts of interest audit with any arbitrator under us.
Thank you very much, Nusri. And I think it's very important what you mentioned, because the idea of this panel is not doing a recitation on the rules, but it's really understanding what's the purpose and the spirit behind these rules. So as many people or many of our users, they can read the rules, they can think about transparency, but thanks, Nusri, for explaining the process, what's happening on the other side from the institutional perspective, how seriously we take conflicts at SIAC and how we conduct this process. So thanks very much, Nusri, for this. And I have a question on the same line of transparency, Joanne, that is a keyword that was mentioned at the beginning. And it comes to my attention, Rule 25.3, which deals with party communications with the arbitral tribunal. And my question for you, Joanne, is how does this rule safeguard transparency during the proceedings? And also, what's your practical experience on this? I think we all here want to know on the practical level, how does this works?
Right. Thank you, Andres. I actually just wanted to take a step back before we talk about Rule 25.3 to just kind of echo something that Nusri said. I think, when we talk about, previously we talked about efficiency, we talked about innovation. I think, the particular need we were trying to address in terms of how users experience arbitration is that we always know it wants to be cheaper, we want it to be faster, we want to have different procedural mechanisms like the PPO to safeguard specific interests. And I think when it comes to transparency in particular, just like Nusri said, what we're looking at now is we're looking at the procedural regularity of the proceedings. We want to make sure that everything is fully above board and there's no procedural irregularity that, may cause there to be concerns about the enforceability of the award. And I think with Rule 25.3 in particular, which states that after the constitution of the tribunal, a party or its representative shall not engage in any ex parte communications about the arbitration with any arbitrator. For those who may not be very familiar with the term, ex parte just means, I think, on a one-to-one basis. So, for example, you have the claimant You don't want to have a situation where the claimant is writing to the tribunal without the respondent knowing, saying that actually, my claim is very strong for all of these reasons, but I don't want you to let the respondent know because the respondent will definitely disagree. We don't want to have such a situation because, when tribunals are interacting with the parties, we want them to be even-handed and fair when it comes to the parties. So the idea is that there should not be a development in the case where only one party is aware of it. Or there shouldn't be a situation where, there's an application and you see comments from only one of the parties. The idea is that everybody should have a chance to participate. The tribunal should be as neutral and as even-handed in receiving comments and, hearing information from both of the parties. And yeah, the idea is really that you want to make sure that everything is above board and you don't have, at the end of a 2-year or 3-year arbitration, a situation where, that there's grounds to believe that the arbitrator might be biased or there may be other reasons why you're seeking to set aside or refuse enforcement of the award. And speaking of practical experience, I think in general, from what I've observed, I think tribunals are quite aware of the need to look impartial and disinterested. And I think my own personal opinion is that Rule 25.3 is sometimes, I think, useful to point to if you need to keep the parties in line. I think sometimes if you have parties who are less experienced with arbitration, they may not quite understand why they can't just, email the tribunal directly and not copy the other side. So I think it is helpful to be able to point to, Rule 25.3 in the SIAC rules and say that actually you shouldn't be engaging in ex parte communication. In any communication with the tribunal, you should be letting the other side know what you're saying as well.
Thanks, Joanne. I think this is very interesting what you just mentioned because it really strengthens transparency in arbitrations under the SIAC rules. And I have a final question on this keyword, and it is for Shibam, because I think that costs are a big part of arbitration proceedings. I think that users are always concerned about cost, regardless of the jurisdictions where they are based. And I think that because one of the functions of Secretariat is conducting the financial management of the disputes, collecting deposits towards the estimated cost of arbitration, my question to you, Shibam, is how are costs determined under the SIAC rules? How the determination of cost works in the rules, and how does this ensure transparency for the users, given that, as I mentioned, the issue of cost is a pressing need everywhere?
Thank you, Andres. When we talk about the costs of the arbitration, it is important to understand what the term really means. Under the SIAC rules, the term the cost of arbitration comprises of the tribunal's fees and expenses, SIAC's administration fees and expenses, the emergency arbitrator's fees and expenses if there was one appointed, the tribunal secretary's fees and expenses, any costs of any experts appointed by the tribunal, and of any other assistance reasonably required by the tribunal, and the filing fees. So all of these terms comprise of what we call the costs of the arbitration. Now, the costs of the arbitration at SIAC are calculated using an ad valorem system, meaning they're based on the value of the total sum in dispute. Now, when an arbitration is first commenced, SIAC will estimate the maximum estimated cost of the arbitration based on the total value of the claims and the counterclaims in accordance with the SIAC schedule of fees. SIAC informs the parties of the maximum estimated cost of the arbitration at the outset. So this would be done to and informed to the parties in the commencement letter itself. And SIAC would call for deposits based on these estimates, typically in tranches. For example, it could be 40% at the commencement of the case, 40% after the pleadings, and 20% before the hearing. Now, the reason I use the term maximum estimated costs is because these numbers are actually only estimates. The actual costs of the arbitration are only determined by the registrar at the conclusion of the proceedings. Now, for example, the parties have been informed that the maximum estimated cost of arbitration is around 100 Singapore dollars. Now, in this case, assuming that the case concludes at a very early stage, right after the tribunal is perhaps constituted, and the parties inform the tribunal that they've arrived at a settlement and they'd like to withdraw their case. Now, the registrar in these circumstances would take into account all the facts of the case and the stage at which the proceedings have concluded, and would make the determination of the cost of the arbitration. In this case, it would not necessarily mean that the cost of arbitration would be determined to be 100 Singapore dollars. It may very well be determined that the cost of arbitration in such a case may perhaps be 20 Singapore dollars, really depending on the facts and circumstances of the case. Now, compared to the other situation that we see often is, if the case has gone the entire distance and an award has been issued by the tribunal, the registrar would then also factor in, the performance of the tribunal, how efficient the tribunal was, the quality of the awards. So as you can see, from the terms that I described or what comprises the cost of arbitration, those are the only numbers that actually make up this entire cost of arbitration. There are no hidden costs involved. And it doesn't matter how many sittings or hearings that a tribunal is done, but the fee cap of the tribunal is the fee cap of the tribunal. Now, in the event that the costs of arbitration as determined by the registrar are less than the deposits paid by the parties, there shall be a refund to the parties of their respected unutilized deposits or in such proportions as the parties may agree. Now, the reason why I also say this entire cost of arbitration process at SIAC is transparent. The SIAC schedule of fees is published online, which allows parties to estimate the cost of arbitration before even commencing an arbitration. In fact, there is an SIAC fee calculator available on the SIAC website, which further enhances this transparency by enabling parties to input their claim value and receive then immediate estimates of the likely costs involved. In fact, the SIAC fee calculator goes as far as to breaking down into what would be the fee caps under a streamlined procedure as well. Now, and of course, the process of calling for deposits and tranches and the final determination and refund of unused deposits also ensures that the parties are kept informed about the financial aspects of the case at every stage. Now, the reason why all of this matters is because this transparent approach to the cost of arbitration helps parties plan and budget for their arbitration with confidence, and there are clear safeguards to prevent unexpected or hidden costs.
Thank you, Shivam. I think that all of your interventions have really encapsulated this word of transparency. We have dealt with the process of reaching out to potential candidates, clearing conflicts, communications between the parties and tribunals, and finally the issue on cost, which is so important when we're speaking about transparency. And it's really important to see how the SIAC really have built transparency into the DNA of the rules. Now we'll move to the final section of this panel, which is the last word, flexibility. And I think I will start with you, Nusri. And I think that every law student learning about arbitration, one of the main benefits that we always hear is about flexibility and how flexibility is such an important benefit of arbitral proceedings. And my question to you is, could you share how the SIAC rules embody this principle and perhaps to give us an example of how this principle operates in practice?
Thank you, Andres. I think for me personally, I think one word that captures the spirit of SIAC rules is flexibility. For the reason that arbitration, after all, is built on party autonomy. And the rules are designed to give users the structure they need while maintaining the freedom that they value. Now, the rules are in place to balance procedural certainty with adaptability. And I think allowing the process to fit the dispute as opposed to the dispute to fit the process, right? Now, on that note itself, why I say the SIAC rules are flexible is in terms of every provision that is there, that you have a reason why it's there. And if you cannot achieve that, there is a certain mechanism to cure it. Now, let's say, for an example, Rule 32 gives the tribunals the power to conduct the arbitration in such a manner that it considers appropriate. Now, if the rules dictated the way in which the arbitration should be conducted, it will be too rigid, and you won't have one fit mechanism or one fit for all mechanism to govern all types of disputes. You have various disputes, small value claims, high value claims, claims that sometimes you need multiple witnesses. So you need to have, the tribunal needs that flexibility itself to ensure that the proceedings are carried out within the spirits of the rules to be efficient as well, okay, and flexible and cost efficient. Now, the next thing is, I would say, is if you take an instance, Shivam spoke about the cost of arbitration, and you take fixing deposits in instances where the parties want an application to have separate deposits because in certain instances claims are conflated or a party is not going ahead with something. you want to have separate deposits, the registrar has, generally the rule is 50-50 in terms of deposits, but the registrar does have that flexibility to fix separate deposits. Now, even in quantification of claims, let's say a party cannot agree. Shivam said that the fee structure, as you know, is based on ad valorem system and is based on the sum in dispute. Now, where parties cannot agree, it's the registrar. The registrar has the flexibility to determine and have a provisional quantification of what the sum in dispute is going to be, so that you can call for deposits based on that provisional quantification by the registrar. That is also a mechanism within the rules. And let's say, for instance, you have a claim and a counterclaim, and the claimant at some point refuses to pay its share of deposits. Now, in terms of the rules, there is a provision which allows the registrar to suspend the proceedings and then subsequently deem the claim or counterclaim withdrawn. So let's say you have a claim and all of a sudden the claimant decides he doesn't want to pursue that claim, so stops paying deposits. Right? What would happen then is, are you going to terminate the entire arbitration, which has now gone ahead, or are you going to allow the counterclaim to proceed because the respondent is paying his deposits, his share of deposits, and proceeding with the arbitration? So in such a scenario, the rules itself provide where you can suspend a claim or a counterclaim and proceed with the other portion of the claim or counterclaim. Now, this is also example of how the rules are flexible itself. And I think another example I would like to give, I mean, I can give you countless examples of how the SIAC rules are flexible, but another example would be where the timelines itself. We spoke about the expedited procedure, we spoke about the streamlined procedure, we spoke about the PPO, the emergency arbitration, and even in terms of the scrutiny timelines, where the arbitrator has to, within 90 days of the final proceeding, has to send across the award for scrutiny to the SIAC. Even those timelines are set in the rules. Now, in certain instances, let's say for an expedited procedure matter, where the timeline is 6 months from the date of constitution where the award has to be issued, for some reason, the parties, let's say, were exploring the possibility of a settlement. And as a result of that, the arbitration was paused. And now they have decided, look, we cannot go ahead with the settlement. We want to proceed with the arbitration. And you realize you cannot meet the timeline. You cannot meet the timeline of 6 months. So you can apply to the registrar for an extension, and the registrar has the powers to be flexible enough to extend the timeline to ensure that the award is valid, because with the expedited procedure, you have the 6 months, now it's extended, let's do to 7 months or 8 months or whatever the case warrants it to be. The next thing is, like I mentioned before, the president's power to reject a nomination by a party where that arbitrator is conflicted or does not have availability. So that flexibility is also given to the president in making those decisions on appointment. And like I said, the person appointing the arbitrators in terms of the rules is the president, right? Now, what if the president is conflicted, right? So the rules are flexible enough. I'm using the word flexible because I think this is a key term for me personally, to say that, look, if the president is conflicted, you have the vice presidents who can come in place in terms of the rules itself to make that appointment, or even the registrar to make that appointment because the president or the vice presidents are conflicted. So, like I said, Andres, the rules, I mean, I can go on for days about the flexibility on each provision that is there, but for me, these are the key takeaways from the rules itself.
Thank you, Nusri. And with this in mind, as you mentioned, flexibility is one of the key features behind the SIAC rules. And Margarita, I have a question for you, because we have discussed the different procedures under the rules, and we can tell how the rules really provide structure. But my question is, by providing this framework, this structure, how do we strike out the right balance between, on one side, providing a structure, providing a procedural framework, and on the other side, really allowing parties and tribunals to tailor the process to their own needs? How do we strike that balance, Margarita?
That's a great question. I think that SIAC rules really strike that balance by combining clear procedural structure with a high degree of flexibility for parties and tribunals. On the one hand, the SIC rules are designed to provide a predictable and efficient framework. Users know what to expect, timelines are clear, and procedures such as a streamlined procedure or expedited procedure ensure efficiency when needed. And as discussed earlier, for example, the streamlined procedure sets out a straightforward process: written submissions only, no document production, and no fact or expert witness evidence, providing structure and certainty. But on the other hand, the SIC rules acknowledge that one size does not fit all, and the tribunals and the parties retain the flexibility to adapt these procedures. Under both the streamlined procedure and expedited procedure, the tribunal may modify the process after, of course, consulting with the parties, where justified by the complexity of the dispute. For example, the tribunal may order, after the consultation with the parties, that the hearings are needed or that a document production phase is necessary in the arbitration conducted under the streamlined procedure, even though it is not by default there. So while the framework provides a clear path, it does not restrict flexibility. In this way, SIC approach reflects, I think, modern arbitration practice. It's structured enough to inspire confidence of the users, but yet adaptable enough to accommodate the realities of the diverse disputes and the parties.
Thanks very much, Margarita. First, before we move to the Q&A section, I just want to congratulate the four of you because you have really shared with us four important principles. We have efficiency, we have innovation, we have transparency, and we have flexibility. And I think this session has been very insightful because these words are not an abstract ideas. These principles are really set in the DNA and they really shape the new SIAC rules. And I think this session has been very insightful. And now I'll give the word to my colleague Swan, who will give some closing remarks. Thank you so much.
Thank you, Andres. Thank you to all our speakers for that very insightful panel session. We hope you enjoyed the discussion and found it useful. To all the students participating in the 2026 WIS Moots, we have put together a dedicated WIS Moot 2026 webpage on the SIAC website. On the webpage, you can find information on pre-Moots activities organized and supported by SIAC, along with other useful resources. As you unpack the Moot problem and apply the SIAC rules in your analysis, we hope that you'll be able to identify some of the innovative features and procedural mechanisms that were shared earlier during the discussion. We look forward to meeting you at the WIS Moot in Vienna, WIS East in Hong Kong, and other events around the world. We wish you all success and the very best in your mooting journey and hope that you will have an exciting mooting experience ahead. Thank you once again for joining us today. Have a lovely day and evening ahead, everyone.
Thank you.
Thank you.